is coming from. But before we get there, is there anyone having a question? Any person having a question? Okay, nobody. So this is the law of the dead. This is the law of the dead. So the law of the dead is relatable, and that this is the only act of parliament that will come in place when somebody dies. This is the only one that will come in place when somebody dies. Okay, so at least everybody, you have an experience with death. At least you've had someone in your family, your village, your country. You've seen someone dying, or you've heard somebody died. Now, even if you haven't, of course, if you're a Christian, you believe that Jesus died for you. And if you're Muslim, I don't think Muhammad died. Did he go to heaven directly without dying? I think that is the case. And now that I'm saying that, you know, if you go to, let me just say that as a side note, if you go to Israel, and specifically the city of Jerusalem, that city is divided into three. The first part of that city is for Christians, and the second part is for Muslims, and the third one is for Jews. They all worship under the same place, but they believe in different things at the same time. And that is how dynamic religion is. You know, the Israelites are not even Christians. Majority of Israelites are not even Christians. But you see the Christians that we have in Africa, they believe that they're the Israelites, you know, and they're very intolerant to other religions, and they think that the heaven is theirs. So the true Israelites are not even Christians. They don't even believe in Jesus. You know, they don't even believe in Jesus. They're the true Israelites. They're the Jews. The Jews don't believe in Jesus Christ, but the Christians do believe, and the Muslims don't believe. Don't believe in Jesus as well. So the next time you want to beat your neighbor for who is more Christian than the other, you need to remember that the actual Israelites, those that are there, who worship under the same roof, they don't believe in the same thing. So it's okay not to believe in the same thing. Okay. So, like I was saying, when you look at the law of succession, really, it is about the law of somebody who has died. Now, why am I saying that specifically? I'm saying that because throughout this discussion, even starting right now, there's going to be a confusion between the Marriage Act and the Law of Succession Act. Now, those two pieces of legislations are very different. They are so different, and they don't merge at any point of view, except in one instance. Okay? The Marriage Act is the Marriage Act, as the name suggests, the Marriage Act. The Law of Succession Act is the law of succession, as the name suggests. So don't think that any of those acts are related and one depends on the other. No, nothing. Are you together? So make sure that you don't get that confusion, because it's going to lead you to not get some points. Now, probate is divided into three, but the first thing you need to understand, the first thing I've said is the scope, that the law of succession only comes in place when there's death, where before death, there's no law of succession. Okay, that is the first thing you need to understand. The next thing that also you need to understand is the legal framework of the law of succession. The legal framework of the law of succession. Now, before 1981, the law of succession was widely common law. Okay, it was just common law that was applicable in the UK or in the British territories, and then it was assimilated and then brought all the way to Africa and then Kenya. So it was common law until 1981 when the Law of Succession Act was enacted. So the main Bible that is going to govern you in this unit is the Law of Succession Act together with the rules. Okay, we have the probate and administration rules that will govern how you are supposed to administer. So everything that you're going to file in court, in as far as the Law of Succession Act is concerned, then that is going to be provided for under the rules. So everything, if it is all the applications and all the pleadings are under the rules. Okay, so that is what we are saying. That is the legal framework for the law of succession, as well as the precedent setting cases. Okay, those cases that set precedents. For example, Otensai Wanjiku Yawe, of course, you know that is a very important case that has never been overturned. So it sets precedents in terms of certain matters. Are we together? So that is what we're saying. So make sure you get those two things. Sometimes people forget that there is something called the probate and administration rules. So if you download the act, in that act also download the probate and administration rules. That is the first thing. Okay, any question up to there? I want to be very, very slow intentionally so that we are not losing anything. We're not losing anything. Any question up to there? Are we good? I will need to employ someone to say, yes, you're fine. I don't know whether you guys know what it takes to speak alone for 2 hours and just talk and talk and talk. You feel like a mad person. So if you say,
can hire,
yes,
you can hire me on their
who is
behalf,
it?
but
Who is speaking? I can't see the person speaking.
this is Seth.
Yes, Seth Wafula. So you are
Yes.
hired. You are hired. So your work is to make sure
Thank
that
you.
you let me know if I'm audible, if everything is fine, so that I don't just speak and speak and speak and speak. All right, so let us start. Let's now kick it and see what this is about. Now, the second thing I will tell you about this one is you need to relearn. You need to unlearn and relearn. Don't be rigid. Don't be rigid. Don't be emotional. This is one way that people get so emotional about certain things, and they're very sad. They're writing exams and they're very, very sad. You know, it's just the law. Don't be sad. Don't take it at heart. Okay, be easy and allow yourself to learn and allow yourself to relearn certain things that you opinions or ideas that you might have that are not actual. All right, now let us get into the deep of it. Okay, let us get into the deep of it. The third thing I will mention, which I've already mentioned, is the relationship between the law of succession and the Marriage Act. Now, those two acts of parliament are like the Evidence Act and the Penal Code. They're not related. They might work together, but they're not related. Or the Water Act and the Evidence Act. Two related things, two related regimes. So the Marriage Act is for marriages. It deals with marriages. Okay? It deals with marriages entirely. So if you want to get married and you want to ascertain whether somebody is married, then you will open the Marriage Act. The Law of Succession Act is all about succession. Sometimes we might want to qualify marriage. So if a question of marriage comes within succession, then we will go back into the law of, the law of marriages, which is marriage. Are you together? So that is what we are saying. So don't say that the law of the Marriage Act nullified something No, that is not how acts of parliament are enacted or amended. Okay, that being said and done, let us get into now the definitions, because it is very important for you to understand who is the subject of the law of succession. The law of succession is very easy, guys. It is very, very easy, very simple. Why is it very simple? Because at all given times, the law of succession is all about distributing the property of the deceased person to the beneficiaries. Okay? So that needs you to understand the deceased person, their property, and the beneficiaries. That is all you need to understand entirely. Who the deceased person is, what is their property, and who are the beneficiaries. That is all it is about. So the first thing you need to understand are, let's start from the beneficiaries. So who are the beneficiaries within the law of succession? The first thing is that the beneficiaries can be anyone. But on top of the list of the beneficiaries, we start by defining who a wife is. Who is a wife? Okay? Who is a wife? So the law of succession defines 3 different types of women that are deemed as wives. So there are 3 categories of women that will be deemed as wives in the law of succession. Now, these women may not be necessarily wives under the Marriage Act, but for purposes of succession, they are deemed as wives. Are we together? So that is exactly what we are saying. So who is the first one? The goat wife. I normally call them that, the goat wife. So the goat wife is the one, that one, the main one, the one that is married under the Marriage Act, that is the wife of the deceased person. Okay, so the first person that is deemed, okay, the first person that is deemed as a wife in the law of succession is that woman that is married under the Marriage Act. So this woman will be coming and saying, hey, this is my marriage certificate. I was married in church. I was married under statute. I was married under the Muslim law. I was married under the Hindu law, or I was married under the Kikuyu, Kamba, or Luya customary law. That is the goat wife. She's yendo mwenye boma. So that is the first person that is deemed as a wife under the law of succession. Okay? The second person that is deemed as a wife or could be a wife under the law of succession is the person we are calling the cohabitation. Okay? Cohabitation. Now, the common law wife, who is a wife that is presumed under common law, is also a wife for purposes of succession, and not just succession. Even for purposes of actual marriage, that person will be considered as a wife. Are we together? Now, this woman, if this man and this woman were staying together in Nairobi, for instance, they met in KSL 12 years ago. They went through their studies, they got married, and not really got married, they started living together, they gave birth to kids, they opened a law firm together, they've been practicing, and then 10 years down the line, without being married, the guy dies. Okay? If the guy dies, then the law allows us to presume this lady as the common law wife, and therefore she will attain the status of being a wife. Are we together? Now, there are a lot of questions about whether cohabitation is still there or cohabitation is not. The answer is very simple. Cohabitation can never go anywhere. Some of you here are cohabiting, even as we speak. Okay, even as we speak right now, some of you are already cohabiting. You are joining this class with your cohabitee next to you. So you cannot argue that cohabitation is not there. It is there. Okay, cohabitation is there. There is no argument. Don't even try saying that cohabitation is not there, because cohabitation is a way of life. It is the day-to-day thing. People will still cohabit. The next question is, can cohabitation lead to a marriage, or can cohabitation lead to a presumed marriage? Then the answer is yes. And why is that the case? Three things. The first one is section 119 of the Evidence Act. Now, the Evidence Act allows us to presume the existence of something based on the facts. Okay? The next one is the common law. Now, presumption of marriage was a common law principle. It is not a statute issue. There is nowhere in the world where presumption of marriage was coined in statute. Why? Because the moment it is written down in statute, it will stop being a presumed marriage or a common law marriage. Okay? And therefore, the question that was raised during that time is whether two people living under the circumstances that I've described for you could lead to a presumption of marriage between the two of them. And the answer is very simple, that even before the coming of the Law of Succession Act and the Marriage Act that was repealed in 2014, and even the 2014 one, people were cohabiting, and cohabitation was deemed to lead to a marriage. Are you together? Now, there's one case law that still stands up today, and that case is Otensaya Wanjiku Yawe. Now, that case was a Court of Appeal case. Okay? Wanjiku Yawe was a Court of Appeal decision that came from the High Court and went to the Apex Court. And that time, the Apex Court was the Court of Appeal. Now, the Court of Appeal said, yes, based on all the legal precedents that have been set, long cohabitation can lead to presumption of marriage. Are we together? A long cohabitation can lead to presumption of marriage. Now, that court set the things that needs to be there. The first one, it should be a long cohabitation. Si siku mbili, siku tatu umepatana KSL, hata project hamja submit, mshaitana mabibi na mabwana. Si hiyo. Okay? This one must pass. It must pass the test of time. Mmekuwa KSL nyinyi wote wawili, 2 years, 3 years, mtoto ndo huyo, business imeanza, meishi pamoja 5 years, 6 years, 7 years, 10 years, you've done life together. That is long cohabitation. Secondly, the court says that apart from long cohabitation, there must be the question of issues. Okay? In the context, when we talk about issues in the context of marriage and succession, we talk about children. So you guys had children together. Apart from children, there were investment. You made substantial capital investment. You had a business. You were doing this and that, And then lastly, that the public perceived you as man and wife. If we go to where you are staying today, we will be told that huyu ni bibia huyu. Are you together? Huyu ni bibia huyu, ama huyu ni bwana ya huyu. So the public views you as married. Are you together? So that was the test in Otensaya Wanjiku Yawe. Now, aside from that, from 2020, now the High Court started messing around that jurisprudence of cohabitation. Some saying cohabitation cannot lead to what. The Marriage Act 2014 came in place, and the question of registration of marriages, a lot of all those things until last year. So last year, the Supreme Court settled the question of Otensaya Wanjiku Yawe, or the question of presumption of marriage. And what is the first thing the Supreme Court said? The Supreme Court upheld Otensaia Wanjiku Yawe by saying that all the factors that are in Otensaia Wanjiku Yawe will still be applicable. However, the Supreme Court added other factors that must be there for there to be a presumption of marriage. So aside from long cohabitation, children, investment, and the public perception, the Supreme Court says that you too must have intended to be married. And the Supreme Court said that nowadays you can live together, but you're not married. Or you can live apart, but you are married. So the Supreme Court added that these two people must have intended to live together as man and wife. Okay? Through actions and through conduct. Number two, the Supreme Court added that they must have the capacity. Okay? They must have the capacity to get married. That during the time that you guys are cohabiting, you should not be cohabiting with someone else's wife or someone else's husband. This man that you're cohabiting with, that you're cleaning his house, no, you're leaving KSL, mbio kwa matatu na boka, unaenda kumtafutia maji. Unampikia, unamwoshea nguo, unamuita bwanako. This man should not be married to someone else. Because if this person is married to someone else, then that marriage cannot be presumed because this man did not have a capacity to get married. Are you together? So the court says that this person, the two of you must have capacity to get married. If this man is already married somewhere, or you as the lady, you're already having some marriage somewhere, then the two of you are just boyfriends and girlfriends. That cannot lead to a marriage. Because remember, when marriage is presumed, you become the legal wife to this person or the legal husband to this person. And therefore, that gives you the legal status to become the wife. But you cannot have that legal status when this person is already having another relationship somewhere, which is a marriage-like relationship. So the two of you must have the capacity to get married. Okay? So that is an entire discussion that the Supreme Court had, and it settled the question of, is cohabitation still existing? Do we have presumption of marriage? Yes, we do. And that is a good decision from the Supreme Court. So make sure you understand that point very, very clearly. So I will share that case in the group if you guys have not seen it. But I'm very sure you guys by now you should have seen it. Okay? So don't be emotional. Okay? Don't be emotional about things by saying, oh, cohabitation now is not there. Oh, side chicks. Oh, you remember all those debates during that time. Don't be emotional. The law is the law. Okay? And when it comes to cohabitation and presumption of marriage, the law is very clear. The rule in Otensaia Wanjiku Yawe is still there. 60 years down the line, Wanjiku Yawe is still living. So, don't get it confused. Don't get it twisted. Any question? No question. Okay. Sawa. So, that is the first bit. So that is the second woman that will be considered, okay, will be considered a wife. But remember that the cohabitee will not be considered a wife if there's already the first wife under the Marriage Act, which I've already said. So you cannot have two instances, the first wife and a cohabitee at the same time. No, that can't happen. Because when this man is already married, you can't cohabit and become a common law wife. You can't have both. The two systems cannot come together at the same time. I hope you're getting what I'm saying because of the question of capacity. Lastly is the third lady, a very special one. Okay, the very special lady under section 3.5, and this is the one that makes a lot of law students very, very emotional. Eliud, what is your question?
Good evening.
Good evening to you too.
Evening. Sorry. Hello.
Yes, hello.
Hello. Sorry
Yes.
for that. The discussion about cohabitation. I have a question. Before we move
Uliza.
forward. Yeah. In a case whereby this man has already sort of is in a maybe civil sort of marriage, or maybe, and he intends to take another wife. Yeah. Maybe this is African customary marriage, and that allows for polygamy. And for some reason, he starts another relationship with another person. So the whole issue of capacity, does it also, are we not also to merit in the basis of cohabitation?
So you're saying you're married and you want to add another wife?
Yeah, in the form like a potential polygamous arrangement, sort of that.
So you're married under Kikuyu and you want to bring another wife under Kamba.
Yeah.
Yes, you can.
So,
that is possible because you have capacity.
So, okay, then is it then right to say that the issue of cohabitation extends to the whole idea of capacity if the man has the capacity to subsist in another union?
You listen, you must have the capacity to have another wife. The question is, when you are cohabiting, did you have the capacity to have another wife? For instance, number one, you must be above the age of 18 anyway. So you must have the capacity to have a wife. Number two, if you are already in an existing marriage, okay? You as, let's say, Eliud, you are married. I'm not taking you out of the market. Are you married? Let's start there. Are you married?
I'm not married, just proceed.
All right. So Eliud is married, but Eliud wants to add another one. So we're going to ask ourselves first, before we assume that Eliud can cohabit until this cohabitation leads to marriage, Eliud must be above the age of 18. Yes, that is tick. Number two, is Eliud married? Then the answer is yes, Eliud is married. Now, if Eliud is married, then we are going to ask ourselves, is Eliud having the capacity to have another wife if he is married? And then we are going to ask ourselves, is he married under church? If Eliud is married under church, no, Eliud cannot cohabit with another woman again. If Eliud married under statute, yes, he is. Then Eliud can not cohabit with another woman. But if Eliud is married under customary law, then potentially Eliud can add another wife. So Eliud can cohabit with another lady, and then that cohabitee becomes the second wife. Tuko sawa?
Sawa.
Yes.
Thank you.
All right. Any person having a question? Let me see. Sorry. Tianga, Jennifer.
Good evening, Mwalimu.
Good evening.
Okay, I want to just to clarify. So this means where one has satisfied all the other conditions set by the Court of Appeal and the Supreme Court, with the exception of not having the capacity to marry, having married maybe under statute before, even though they have been cohabiting, still this person would not be considered as a wife for purposes of succession. Is that what you're saying?
Yes, what I'm saying is that all those things that I've said, all of them must be there. You have to satisfy all of them. If one is missing, even if you have capacity, you have capacity, you know, you have capacity, but you didn't intend to get married. One factor is already out. Okay? You have capacity, you intend, but it is not long cohabitation. That is not presumption. So all those factors must be present. All of them must be present. If one is missing, then you guys are just boyfriend and girlfriend. Tuko sawa?
Sawa, thank you.
Okay. So, I don't know whether there's another. No, there's no other question. All right. So, someone is saying, is asking a question in the chat and saying, but I have a question regarding capacity. A man married under customary law procures another marriage, say Christian marriage, where he can go ahead and do the wedding. Does the second wife claim property under the LSA? Yes, that is now section 3.5. Okay, that is now section 3.5. So, Reese, Aaron, this is the section that we have for you. So, the first wife, tick. The goat wife, tick. Mwenye boma. Second one, cohabitee. That remember, the first one and the second one cannot exist in the same space. And then the third wife, the third person that can be considered as a wife is the wife under section 3.5. And this is where people get it wrong. People get so emotional under this section. Now, the first thing that I will tell you, that if you are sitting in this class and you're thinking at the back of your mind that this section was amended by some amendment act, you need to unlearn that and learn this one. Section 3.5 has never been amended. Section 3.5 has never been amended unless it was done last week. Okay, unless it was done last week, that I don't know. Okay, I'm not sure the parliament thought last week and amended this section. I'm not sure, but it hasn't been amended. 3.5 has never been amended. And somebody saying that the Marriage Act amended section 3.5, that person is not right. And we are going to see why. Are we together? Now, I want somebody to read for us section 3.5. Read it very slowly and also so that we are all understanding. So let me try and okay, that's the best I can do. Somebody read it.
Can I read?
Yes, that's what I'm saying.
Oh, okay. Section 3.5 of the Law of Succession Act, notwithstanding the provision of any other written law, a woman married under a system of law which permits polygamy is where her husband has contracted a previous or subsequent monogamous marriage to another woman, nevertheless a wife for the purpose of this act, and in particular section 29 and 40 thereof, and her children are accordingly children within the meaning of this act.
Yes. Very, 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 very simple. Very, very simple. Are you together? Very, very simple. So don't confuse it. Don't confuse it. Don't confuse it. That notwithstanding the provisions of any other written law, a woman that is married under a system of law which permits polygamy is where the husband has contracted a previous or a subsequent monogamous marriage to another woman, that woman is nevertheless a wife for purposes of this act. That is what I was saying. She is only a wife for purposes of the law of succession. She is not a wife for purposes of the Marriage Act. And that is why I'm telling you, the Marriage Act has nothing to do with the Law of Succession Act in as far as section 3.5 is concerned. So that woman is not a wife when it comes to the Marriage Act. So if we start going through the Marriage Act, we will not call her. But when we get to the Law of Succession Act, we will call her. Okay? So if we are going to be calling the ladies, so the first one, we will stand at the door as the administrator and we will be saying, it is now time for us to distribute the estate of the deceased person to the wives of the deceased person. So we will be calling the first one, who is the goat wife. Okay? She will come in and sit down. Okay? The second one we'll be calling is the cohabitee, if there's any atakuja ataingia ndani. And then the third one is the woman under section 3.5, atakuja ataingia ndani. Now, after we are done distributing the estate, the woman under section 3.5 will leave. She will disappear and never to be seen again. But the first wife and the cohabitee will remain, because those two are actual wives under succession, and they're also wives under the Marriage Act. So if we are going to be discussing duties of the wives, we will discuss that aspect with the first wife as defined under this act, and also we will discuss that with a cohabitee. Suppose this person did not marry under the Marriage Act, but he married under the common law, which is the question of presumption of marriage. But we cannot discuss wife duties with the woman under section 3.5. Why? That woman is only a wife for purposes of succession. It means kama kuna succession, that lady will not exist. She will only exist for purposes of succession. The jurisdiction or the locus of that lady is only in as far as succession is concerned. And that's why I keep telling you that whatever is written in the Marriage Act has nothing to do with what is written under section 3.5. Guys, are we together? Tuko sawa?
Yes, we are together.
Seth Wafula, you are fired. So,
we are together.
so that is what it is. That is what it is. So I want you to understand first, because you cannot understand what section 3.5 is before you understand even the history of section 3.5. So let's go into the history of section 3.5. Okay? Now remember that section 3.5 is an amendment that came around 1990. That is sometime after around 10 years after the Law of Succession Act. 9 years after the Law of Succession Act. That is when the law, section 3.5 was inserted. Now, why was section 3.5 inserted? If previously, there was no section 3.5, but it was inserted for a reason. Okay? Why was it inserted? Because there used to be an offensive section in the old Marriage Act. Now, what that section was saying, that a man could not get married under two systems of law. Now, that specific section has still been carried up to today in the current Marriage Act. So in the Marriage Act of today, you will still go to that act and you'll find a provision saying nobody should marry under two systems of law. It means you can't marry under statute and marry under church. You can't marry under church at the same time under customary law, or you can't marry under statute and under the Muslim. You can't marry under two systems of law. And that developed the principle of capacity to get married. So once you get married under one system of law, you lose the capacity to get married under any other system of law. Are you together? So that specific section promoted the creation of section 3.5. Okay? The mischief under that section. Now, what used to happen? Number one, Riogola. Okay? Number two, Rirwenji. You know those two cases. These are two cases that were established before 3.5. Okay, what were they saying? What were they saying? Now, in these cases, Riogola and Rirwenji, the deceased person died. Okay, they had married under church. They came to town, Nairobi City, the city of stones. They got a job. They met new women. They married these new women again. And then they died, because somehow men will die first. You know, somehow men die first, and it's a reality of life. You know, even biologically, men usually die first. You know, so men die. Even when you look at the marriage, the Law of Succession Act, even the way it was enacted, if you read it through, though they have started doing some amendments to it because they have realized things are changing. That act was enacted specifically for the sole reason that men will die first and men will leave their women behind with their wealth. Okay, that was the motivation. So somehow, some way, the men in these two cases died first. So when they died, there was a battle between now the wife in the village and the wife in town. So this one says, oh, I met this person late in life. Okay, we were married. I didn't know he was married in the village. The first wife will be saying, no, my dear, I'm sorry for you. I am the goat wife. And then they go to court. So when they go to court, what did the court say? The ruling and the finding in both cases were the same thing, that this man did not have, okay, both Ogola and Rwenji did not have the capacity to get married. So you, the second lady from town, we are sorry for you, but you can't get anything. Okay? You can't get anything from the estate of this person. Those are the two cases. Let us go to the one that you know, the Reuben, Nzioka, Mutua. Okay? So in this Mutua's case, you know very well what happened to Mutua. This guy leaves Cumberland, married, very well with children, comes to Nairobi, gets a job, gets another fine babe in town, marries this one again, a child, and then, as fate will have it, he will die fast. I think maybe God was punishing this man. The moment you leave your wife in the village and you come to the city and get another wife, wewe kifo yako inakuja. Kifo yako inapanda tu gari saa hiyo. So they will die fast. You know? And Reuben followed again. Reuben died. So when Reuben died, and the wife in the village came to take the body and everything that Reuben used to own in Nairobi, the second wife said, "Who are you? Do I know you? This is my man, my man. And then they went to court. So when they went to court, the court said, no, Reuben Nzioka Mutua did not have capacity to marry you. So you, the second wife, we are very sorry for you. There's nothing we can do. Okay, but you can go and talk nicely to the first wife if she can give you something. So that was the mischief. That was the mischief. Now, because of that mischief, that men were becoming men and remaining men and always lying, coming to the city, getting new ones and getting married, and they were not changing. So the only thing that had to change was the law. Okay? The only thing that had to change was the law. Now, what was the reason why these judges were overturning these ladies, were telling these ladies that we're sorry, we can't help you? Because of the Marriage Act. Okay? Because of the Marriage Act. And that is where the problem between the Marriage Act and the law of succession started from. Now, these judges were looking at the Marriage Act and saying, they're reading that phrase and saying, no man shall marry under two systems of law. Now, if this Reuben Nzioka Mutua was married under church, he can't marry you again under Kikuyu customary law. No way. So for you, young lady, we are very sorry for you. Now, how did the parliament fix that mischief? How was that mischief corrected? That is what I've highlighted in brown. If you look at my screen, whatever is in brown, the first statement under section 3.5, that was how the mischief was corrected. How was it corrected? By inserting the words, notwithstanding the provision of any other written law. It means from today henceforth, we don't care about what the Marriage Act says in terms of capacity to get married. Okay? What did the Act say again? A woman like the one in Reuben Nzioka Mutua, Riogola, and Rwenji, who is married under a system that permits polygamy, okay, where the husband has contracted a previous, like this one's contracted previous, they had married before, or they married after, okay, notwithstanding that fact, they are considered wives for purposes of this act. And in fact, their children are children of the deceased person according to this act. Now that sorted, okay, that sorted that mischief. And then the next case that was filed in the High Court was Irene Njeri Macharia. And what did the court do? The court upheld section 3.5 by saying Irene is a wife for purposes of succession, and the child of Irene was a child for purposes of that, for purposes of this act again within the meaning of Section 29, and everything that Njogu used to own was given to Irene's baby. Okay? So the court upheld Section 35, and ever since till date, the courts of Kenya have been upholding Section 35 by saying that if you get married as a man, you come to the city, you get a new lady, okay? You get a new lady, you start a life here, you give birth to children. Remember, whatever you leave behind, this second lady will also enjoy with your first wife in the village. But in that entire thing, I think there's only one lesson that or maybe a question that I keep asking myself. How nice were these women of those days? You know, how nice were these women of those days? Yani, your husband will live in the village for 10 years until they get married, and you only know when they're dead. They're very nice women. We need to go back to those days. You know, we need to travel back to those days when women could stay in the village and don't disturb their husbands in town because they know their husbands are working. Nowadays, hata ukienda to town 30 minutes tu, umetoka tu kwa nyumba 30 minutes, umeenda town. DCI iko tu kwa nini yako. Women nowadays are not giving men peace. You need to learn from these women in Riogola, Rirwenji, and Irene Njeri Macharia, because we need peace. Men need peace. For us to work, we need peace. You know? And you see how the world was very nice. Just stay in the village. Tukisema we kaa ushago, kaa tu ushago na ulinde watoto. Tutarudi. Okay? So that is the thing. So from there, the courts have been upholding the ruling in Irene Njeri. So Irene Njeri Macharia overturned the decision in Ruben Zioka Mutua. So that is why Section 35 is there. It is there to seal. It is there to seal that mischief. And what is it saying? Notwithstanding the provision of any other written law. It means there is no written law somewhere that can overturn Section 35. So until the parliament sits down, which they have been trying to do that all the time, until the parliament sits down and say, Section 35 is hereby deleted. This section will not be deleted. Are you together? This section will not be deleted. You can only delete it by directly deleting it. Why? Because it has a protective gear by saying, notwithstanding the provision of any other written law. So don't sit there and tell yourself, oh, see, Marriage Act nini. No, come on, sit down, relax. The Marriage Act has not overturned anything. Okay? It is marriage. This is succession. So notwithstanding the provision of any other written law, huko, in the Marriage Act or anywhere, this section is strong. It is very strong and very strong. That is the first thing about 35. The second thing I want to explain about 35 and give you an example is A, B, and C. Okay? So, assuming that Reuben, let's use the word Reuben. So Reuben marries A under church. Okay? And then marries B under Kikuyu customary law. And then he dies. B, who is married under Kikuyu customary law, is the one that is covered under Section 3(5). And therefore, B will be considered a wife for purposes of succession and only that. The second instance, that is previous monogamous marriage. Okay? Now, the second instance is Reuben marries A, okay, under Kikuyu customary law. Reuben anatoka Kenol. Anachukua nini zake anakuja Nairobi. Akifika Nairobi, life of the city. Okay? Then Reuben marries who? Marries B under the AG. They go to the AG and they swear the affidavit or under church. So in this instance, we are not protecting the second one. We are protecting the first one he left in the village, A. So A will be the woman under, the woman that is being protected under Section 3.5. Why? Because she's the one that is married under a system that permits polygamy. So statutory marriages and Christian marriages and church marriages, they rank higher in priority over customary marriages. So if you get married under church, if you get married at the office of the AG, that marriage will stand over the one under customary law. And that is why the law came in to protect this woman, whether this woman is the first one or she's the third one. Okay? Tunasikizana?
Yes.
Yes.
Mwalimu.
You kindly explain it again.
All right. So who is asking? I want to use you as an example.
My name is Wakiaga Stanley.
Yes, Stanley. You're married?
Yes, I'm married.
Good. So, assuming that Stanley from Beta marries a lady, okay? They go to church, they sign their marriage certificate, a very nice wedding. So Stanley is married. Okay, in 2010, Stanley has married a lady under church, and the lady is called, let's say, Lady A. Stanley comes to KSL in Nairobi, and Stanley say, we kuna warembo huku. Stanley finds another lady, stays with this lady, and then marries this lady, Lady B, under Kikuyu customary law or Kamba customary law. If Stanley dies, we are not protecting the first wife, which was married under church. We are protecting the lady that is married under Kikuyu customary law. So the question you need to ask yourself, for you to identify the woman protected under Section 3.5, the question is, who between the two of them is married under a customary law or a system that permits polygamy? Okay, who? Then the second one. Okay, so what you need to have at the back of your mind is that this lady can be married first or they can be married second. It doesn't mean that in the cases that I've said, these ladies under Section 3.5 were married later in life. But under Section 3.5, they could also be married under the first instance. So we have said the first instance, Stanley married under church, signed a marriage certificate, akona ring kwa mkono yake. Okay? Some ladies see that ring as a green flag. They don't see that ring as a red flag. So, ako Nairobi, amepatana na mwingine, marries the second wife under Kikuyu customary law. Now, legally speaking, this lady married under Kikuyu customary law is not a wife because Stanley does not have capacity to get married in the second instance. Okay? So we are protecting the one that is married under customary law. Now, the other way around, Stanley could have been married in the village under the Luo customary law. Stanley comes to town, meets a beautiful lady, and Stanley gets married again, but this time in church. So when Stanley gets married in church, then automatically this church marriage will nullify the previous customary marriage. And therefore, the woman that we're going to be protecting under this system is the first wife who was married under customary, the Luo customary law. And the reasoning is very simple, that statutory marriages and Christian marriages, they rank over traditional marriages. They rank over traditional marriages. Are you together? They rank over traditional marriages. And that is why we will move to protect whoever was married under a system that permits polygamy. But another instance is if Stanley was married under church and Stanley comes again and gets married under another church, no one is under Section 3.5 there. If Stanley was married under statute, the second wife is married under church, we are protecting no one. If Stanley was married under church and Stanley meets a Muslim lady and he wants to marry this Muslim lady, none of them is being protected. Because there are two different systems of marriage. So one of them must be customary, and one of them either church or statute. So the one being protected is the one under customary. So ask yourself, this lady has come to you, or you have a situation that one was married first, another one was married second. So who do you protect? The one married under customary law. Are we together? So that is the one who is under section 3.5, and their children are actual children of the deceased person, and therefore they will have to inherit as children under section 2.9. Stanley, are we together?
Yes, we are together. And I just want to ask just one small question. Relate to just what you've just explained. Now, in the instance where there is a cohabitee who has met all the requirements, then the man moves to another town and marries under church and dies the following day. What happens in this?
Then we can't throw this section, because remember, if you are cohabiting and then you move to another town and you get married, then that therefore means then cohabitation ceases to exist. I want you to understand. I want you to see it this way. See it this way, Stanley. Assuming you are in Kisumu, you are living there very well, nice. You have a lady there you are cohabiting with. You have cohabited for 30 years. Okay, you have 10 children. You have properties you've invested together. Okay, and then 2 weeks later you move to Nairobi, and then you marry another lady. The moment you marry this lady, that cohabitation will stop existing, and you cannot presume marriage from that. Okay? Because two things are going to stop existing. At the point we are presuming the marriage, is you, Stanley, having the capacity? No. Is you having the intention? No. How do we know you don't have capacity? You're married in church. How do we know you have the intention to get married to this lady? You've married another lady. So it's simple. The courts have said, for there to be presumption, there must be capacity, number one. Number two, both of them must intend to be married. So we cannot presume, you cannot presume that there's marriage here if the man has acted in a way to show that they don't want to get married to this woman. It will be different if you cohabited and you died, and therefore we have to presume. But in this case, you went to another town and got married. So essentially, you avoided this marriage. And of course, remember that the court, something I didn't mention, the court said that cohabitation is avoidable marriage. It is avoidable marriage. Okay, we can presume it, but if one party says we are not married, then you're not married, because that takes away the question of intention. Tuko sawa, Robert?
Yes, tuko sawa. And what happens if the second marriage is now not in church, customary, after cohabiting for all those years and all the requirements of cohabitation are met?
Then both of them are your wives. All of them are your wives. The first wife is a cohabitee, common law wife. The second wife is a Kikuyu customary law. All of them are your wives. Ni wako.
Thank you.
It only becomes an issue. Remember, you can cohabit with 100 women, and all of them will be your wives through cohabitation. All of them. You can cohabit with all, because remember, when you're common law, you can have as many wives under common law, because it permits you to do that. It only becomes a problem the moment you start involving church and statute. So the moment church is involved in statute, there's no cohabitation anywhere. Okay? So that is why cohabitees will not find their way under section 3.5. Cohabitees don't find their way under section 3.5. Nowhere. Because the moment section 3.5 comes, and I want you to see the one I've highlighted in blue. why cohabitees don't find their way under section 3.5. Whatever is highlighted under blue, where the man had contracted a previous or a subsequent monogamous marriage. So if this man already has a marriage somewhere, then they cannot be cohabitation. We cannot presume marriage from that. Why? Because the Supreme Court has said clearly that that man does not have the capacity. Now remember, this section 3.5 is supposed to negate the question of capacity in the context of you getting married in church at the same time under customary law within the Marriage Act. So for there to be cohabitation, there must be capacity. So if that capacity is not existing, you cannot even find yourself here. Okay, so this section has nothing to do with cohabitees. Cohabitees are different sections of people, and there are different parameters of qualifying cohabitees. When it comes to section 3.5, we are just qualifying, these girlfriends, people that were married when this person was already married. Okay, and therefore they don't, and that is why whatever is in yellow, she's only a wife for purposes of this act. Now this section is not for cohabitees. Why? Because cohabitees are actual wives. But this section, the woman under this section is only a wife for succession only. Succession ikiisha, yeye pia ameenda, amepotea. So this section has nothing to do with cohabitees. Nothing at all. It does not protect cohabitees. It does not talk about cohabitees. No. For us to start talking about cohabitation, there must be one single thing. Okay? Which is there's a man and a woman that were staying together. Okay? Man and a woman, they were staying together and one died. And therefore we presume. Okay? But in this instance, we are saying there are two marriages existing. Okay? There are two marriages existing. So I want you to understand that bit. It's a question from Omwenga. Mara.
Just wanted some clarity. So for cohabitation to exist, all the 6 requirements you mentioned has to be present.
Children doesn't have to. We don't have to have children. Sometimes not everybody will be privileged to have children. Some will not have children biologically. Some of them will not want to have children. So children is not a factor. Investment also is not a factor. It's a factor, yes. Let me say it this way. Having a child is a strong point to support cohabitation. But having no child doesn't mean there is no cohabitation. Having a property together doesn't, is a strong point to support presumption of marriage. But having no property together doesn't negate the existence of that. So some points will just support it more, but will not negate it. But certain things must be there. Capacity is a must. Intention is a must. Long cohabitation is a must. Okay? So some must be there. Some should be there. If they're there, well and good. If they're not there, again, public perception should be there, must be there. So those are the things that must be there. So some of them, of course, children, you know that not every family or every married people will have children. Some are not blessed to have children, and some are also not intending to have any child. So you cannot qualify that or disqualify it just on the basis of children. But the fact that you have a child with this person is a huge, strong point towards presumption of marriage. Tuko sawa, Omwenga?
Yes, thank you.
All right. And also remember that even the question of children, when 1981, or even during the common law, when Otensawa and Njiku Yawe was enacted, things were different. The world has changed nowadays. In those days, marriages were only qualified, and people will see the seriousness of a marriage if only you have children. If you don't have a child, even your parents will be saying, my friend, look for another one. You know, look for another one. We want to see things. We need to see children playing here. But things have changed nowadays. People will get married for 30 years. They don't even have a kid, but they're married, legally married. So we have moved from that age in time where children was used as a qualifying factor of people that are married. Nowadays, things are different. We are looking for other things like intention. Living together doesn't mean that you guys are married. There must be intention to get married, capacity, and all those things. Okay, so that is the discussion around the women in the wives. Husbands are not disputed. Husbands are not disputed. That's why we don't have the man under section 3.5. We don't have the man. Maybe with time, 30 years, the people that 50 years later, people will be still doing this course in the next 50 years. Maybe the act will be amended and you'll have now the man under section 3.5. This is the man who has been cheated. This is the man who has been cheated and he thought he was the only man. Kumbe he has a co-husband somewhere. So things will change. Like there are things you never say never. You know, never say never. If you leave this world and you come back, you will find very funny things in the law. You're like, what happened here? Yes, you'll find women now are the ones, they delete 3.5. Now they have the woman and the man under, maybe the man under 3.6. Those men will be suffering. So yes, for now, we don't have that because the law does not allow, a woman to get married to two men. You can't get married to two men. But of course, in Nairobi, kwa ground, unajua, kwa ground vitu ni different. Vitu ni different kabisa. But legally speaking, a lady should not get married to two men. Traditionally, biblically, it doesn't make sense at all. Okay, but like I've said, things are changing. There's certain things we have in the law right now that could not even be dreamt of in 1981. Okay, in 1981, that things have changed. Okay, so that is that. So the second one is a child. Who is a child? There are three people again that are considered children. There are three people that are considered children under the law of succession. The first one is the biological child. Biological child. Okay? The biological child of the deceased person, so long as they are born alive. Okay? The biological children of the deceased person, that child is a child of the deceased person. So essentially, before I jump to children, what I meant to say that if you read a question and somebody has come to your office and they're claiming that they're married, they're entitled to the deceased person's estate because they're wives, you have to take them through this stage and ask them, my dear, your wife as how? Are you the goat wife? You'll be saying, no, I'm not. Okay, fine. Were you cohabiting? No, I'm not. And then you take them through the third stage, which is, are you a lady under section 3.5? If they don't fit any of that, then you tell them, no, I'm sorry, you can't inherit. So there are only three people and three instances that can give you the heart of being a wife in the law of succession. Marriage Act, which is you are married legally, and then cohabitation, presumption, and then the woman under section 3.5. Let's go to children. The first thing that if somebody comes to you and they're telling you, I am a child, because remember, in the entire paper, in the entire law of succession, what are you discussing? Who should get what? Beneficiaries, children, and wives. So the next one is biological children. They are the children of the deceased person. Bernice, you have a question? Bernice?
Yes, I have a question. Sorry, before we maybe move on to children, I wanted to ask, who is a former wife?
A former wife is a separated wife. Judicially separated. No, a divorcee is not a former wife.
Okay.
In the context of section 2.9, we'll talk about that again. In the context of section 2.9, a former wife is a judicially separated. There is still a wife really, but judicially separated, pending the decree. Absolutely. So they are judicially separated, not divorcees. Divorcees cannot inherit from the estate of the deceased person. They can't, because once you divorce, you take your share, I remain with my share. How then, if I die, you still come back for my share? Does it make sense? Doesn't make sense at all. So divorcees are not former wives. Former wives are women that are judicially separated, but not divorced. Okay. Sawa. I thought I saw some hand. No. So the children who, if somebody comes to you and they're claiming that they're children, then the next question that we are going to handle is children. So the first one is, are they biological children? Children that are conceived of the deceased person, okay? And there are parameters to that. The first one is that they have to be born alive. They have to be born alive, okay? They have to be born alive. So that, of course, changes and means that life starts after birth. So they have to be born alive. So even if they're born today and they die tomorrow, that someone is having the microphone on. If they die today, if they're given birth today and they die tomorrow, they're still children of the deceased person and they'll be counted as children of the deceased, so long as they're born alive. So if they're not born alive, like the stillbirth, unfortunately, that is not a child within the meaning of the law of succession. Okay, so that is the first one. And number two, the second twist to that is that if the deceased person, they must be born alive, number one. Number two, they must be born during the life of the deceased person, when the deceased person is still alive. But if they're born after the death of the deceased person, they must be born at least, not at most, 9 months. Okay, 9 months after the death of the deceased person. Some courts do stretch it to 1 year, but I don't think there's a pregnancy that takes 1 year. So the reason is, if at all that was the last thing the deceased person did before they died, maybe they died, you know, in the battle. Men die in battle. So if this man died in the line of duty, then we will expect that 9 months after his death, a child will be born. Okay. If that is the last thing the deceased person did before they died, then 9 months after that specific thing, there's the child. We should see the child. But if you give birth to a child 12 months later, that is not the child of the deceased person, because there's no way in hell that that child was conceived by. So the law gives 9 months because we are assuming, suppose this man died in the line of duty, then 9 months from that date of the battle to the date, or to the last day of the 9th month, we should see the child. So we'll ask ourselves, was this child born during the life of the deceased person? No, it was born after the death of the deceased person. How long after the death? Okay, then it should be at most 9 months, because that is how long it takes to give birth. Okay, the pregnancy should take at least 9 months, or at most 9 months. Actually, at most 9 months. Yeah. So still, biologically, I've not heard of instances where someone has given birth after 15 months. Maybe it happens, but rare cases. But normally it's 9 months, and that is what the law insists on. Some courts do stretch it to at least 1 year. So you have a 3 months allowance, at least 1 year. Okay. Now that is the first one. Now this child will inherit absolutely. They don't have to show anything. They only need to show the birth certificate. Okay, that is the first one. The second one are children that are legally adopted. Legally adopted. The children that are legally adopted. So adoption gives responsibility, parental responsibility. So if you adopt a child, that child is deemed to be your child as if you're the one who gave birth to that child. So again, adopted children are deemed to be part of biological children. So if a child is adopted, they'll have the same right as a biological child. Are you together? So that is because adoption gives rise to parental responsibility. So they will also inherit as a matter of right without having to show any maintenance. And then the next person online is this child that is listed under section 29 B, the child that was taken in by the deceased person. Okay, the child that was taken in by the deceased person. So let me just move to 29 faster and then show you. So the child that is taken in by the deceased person, this child will become the third child, but for him or her, they will have to show maintenance. So the children of the deceased person. So this phrase here that I've just highlighted, that phrase stands for biological children and adopted. Okay, and then we have children whom the deceased person had taken in as his own. Now, this second category is now a different set. For this one, they have to show maintenance. They have to show that the deceased person was taking care of me, because what made the deceased person take you in is the provision that they were providing for you. So if they die, whatever we are going to give you, the reason why we are asking you to show maintenance is because whatever we are going to give you is only limited to what the deceased person used to give you. So if the deceased person through your entire life, the deceased person was just paying for your school fees, then we can't give you more than the school fees. We'll only give you the school fees. And that is why you need to show maintenance. So maintenance is what they are doing for you. So those are the three kids, the three people that will be deemed as a child. So if somebody comes to you in a question and they're asking you, I want to inherit, this person is my father. You ask them, were you born of this person? No. Were you adopted? No. Were you taken in as their own? No. Get out. Okay? So they can't inherit if they don't fit within the three limbs. So that is the test when it comes to the question to do with children. So children must always show maintenance if they're taken in. If they're adopted or biological, they have to inherit as a matter of right. Okay? So that is the discussion on children. The next discussion is now dependents. As the screen is already showing, dependents. So dependents are divided into three. Dependents are divided into three. So who is the first dependent? The first dependent is a group of people that don't need to show maintenance. Okay? The wife or the wives. Okay? So this one, the one I've highlighted now, let me just remove this one. The one I've highlighted right now, the wife or the wives, okay, includes the three that we talked about, the goat wife, the cohabitee, or the woman under section 3.5. They are part of that. They don't have to show maintenance at all. Okay. Number two, former wife or former wives, judicially separated. So if you are judicially separated, you are going to be inheriting without showing any maintenance. Okay. And then thirdly, are children of the deceased. Okay. Children of the deceased. And the law is very clear that whether or not they were being maintained immediately prior to the death of the deceased person. So those are the first privilege. They don't have to show maintenance. The wives, which includes the three categories, the former wives, judicially separated, and the children of the deceased person. So guys, probate questions are very long. They have a lot of stories and a lot of names. So in that story, you need to identify who, and who. Okay? Who is claiming to be a wife? Who is claiming to be a former wife? Who is claiming to be a child? So that you don't get it confused. And then we have the second category of dependents. Okay? Who is the parents? The parents, step-parents, grandparents, stepchildren, children of the deceased person that were taken in, the children that the deceased person took in, brothers, sisters, half-brothers, half-sisters. These ones must show maintenance as were being maintained by the deceased person prior to the deceased person's death. So these ones must show maintenance. Are we together? They have to show maintenance. The second tier, okay? The second tier of the the dependent, they have to show maintenance, okay? And then lastly, he's a very special man. He's a very special man. In other words, they call this person a Ben 10. In other words, I don't know what they call him, but he's a very special man. Huyu ndo amewekwa. Huyu ni wale wa kuwekwa. So utaenda kotini na useme, oh, Yona, huyu mama mwenye ameenda, huyu marehemu ndo alikuwa ananilisha. May thunder strike you. So it's the man. So this man must show maintenance, and it's very unfair because even the law is refusing to believe that this man was being maintained by the wife. So the deceased person as was being maintained, but of course the courts have said that no, this man doesn't have to show maintenance. You know, so that aspect has been amended. You don't have to show maintenance as a man. But again, it's funny, just funny. But yes, if your wife dies, you should also get the same treatment. So this person here, let me highlight it. This person here has been given the same treatment as now the wife. So we're just waiting for the Honorable Attorney General to effect the amendment to Section 29C, which was declared unconstitutional by the High Court. So from today henceforth, you as a man, you also have the same right as the wife. So the husband will also not have to show maintenance. But the original position is that this man was also supposed to show maintenance because the law can't believe. But anyway, now we are believing. Sawa. So that is dependence. So unless there's a will, guys, unless there is a will, the beneficiaries will only be these people. Okay? And any person that can go to court to claim that they want something, they should only be these people that are listed under 29. That closes the discussion about who is a wife, who is a child, and who is a dependent. Now, the will can have as many. You can include your pastor, your cousin, your friend, your workmate. You can all put them as dependents or beneficiaries in your will. But unless there's a will, then there is nothing to discuss, and the only person that can inherit is the person listed under Section 29. Let me take a few questions. Alingo Penina.
Yes, Mwalimu, can you hear me?
Yes.
Okay. I have a question. When you have discussed the issues with dependents, that part, the wife or wives or former wives, I believe there is the Law of Succession Amended Bill of 2021. I believe that is Section 3. It does not provide for amendment of Section 29 of Cap 160. If I read verbatim, it says Section 29 of the Principal Act is amended by A, deleting paragraph A and substituting therefore the following new paragraph: spouse or spouses and the children of the deceased, whether or not maintained by the deceased prior to the deceased death. Now, does it mean that we are completely excluding the former wives, the statutory separated wife, like they are not considered as wives or spouses?
You're the one I was looking for. You're the one I was looking for. Read for me the title of whatever you're reading. On the very top.
title,
On the very top.
special issue, Kenya Gazette Supplement number 35, Senate Bill number 15. It's a Senate bill. Kenya Gazette Supplement, Senate Bill 2021, Nairobi, 12th of March 2021.
Yes, and it there. Yeah, the one I was looking for. Yes. So that is a bill. That is not an act. It's not an amendment. So like I've told you, and maybe I didn't explain, let me explain it. In 2021 of November, the parliament through the sponsor was Opondo Kaluma, who is the MP of Homa Bay, is a man that has serious appetite and libido problems. There's a lot of women, a lot of children out of wedlock. So he was trying to cover his tracks by amending the Law of Succession Act as well. So there are a lot of proposals. Whatever you're reading is a bill. That is what was presented to the parliament for consideration. Okay? That is what was presented to parliament for consideration. Now, the parliamentarians didn't agree with Kaluma, and they dropped a lot of those proposals. And the only thing that made it to the Esprit, that is the house on the hill, the State House, for signing, was amendment to Section 3, which is now reading the question of the spouse or spouses as per the Marriage Act. So it did not amend Section 29. 29 was not amended, but originally 29 was supposed to be amended. 3.5 was to be amended. 3 was to be amended, but it didn't go through. So when the law was signed, when the act, if you download the marriage, the Law of Succession Amendment Act of 2021, you'll realize that only one thing was amended. All other proposals were dropped, and then whatever was signed by President Uhuru Kenyatta is not what is in the bill. It is what was the only one thing that was presented to him for signature. So yes, discard that bill and get the act. So only one thing was amended, and that is why I was telling. And remember, there's a lot of debate around that amendment. There's a lot of debate. Maybe you are still in campus, but there's a lot of debate in terms of, even the media, people were very happy saying, now side chicks have been locked. Side chicks are very powerful. If there's a powerful revolution that cannot even be locked down by the law, is the side chick organization. It is very strong. You can't lock it down. They're very, very powerful. So yes, and you remember that even the headlines used to read, now side chicks have been exempted. My friend, side chicks are very powerful than the KDF. So they are still strong and standing strong years later. So that is a bill. That is what was presented for consideration, but it was never signed into law. Tuko sawa?
Yes, Mwalimu, thank you.
Right. Robert Stanley Okiaga.
Well, Mwalimu, I'm only reminding you of a statement you started with, but you did not complete. You started by saying that probate is divided into 3 parts, but you did not go ahead to tell us the 3 parts.
Tested, intested, and grants. I would still have mentioned it later. So tested, intested, and grants. That's what I was meant to indicate. Mudhoni, Wamuremi.
My question is, what would be the recourse of the divorced wife if she had not applied for matrimonial property? For division of matrimonial property.
Then how do you not apply for matrimonial property? But anyway, so if you are a divorced wife, normally a decree will come in place. The moment somebody gets divorced, then you activate the Matrimonial Properties Act, and then now we start distributing the distributing the the estate. So anything that is a matrimonial property will be distributed according to the law of the Matrimonial Properties Act. And that therefore means before we distribute what belongs to you as Muthoni Murimi to your beneficiaries, we have to give your divorced wife a share of the matrimonial property. So whatever remains is what we will distribute. So you can't distribute before you pay off. Remember that this is a debt of the estate that must be paid. Okay? You only distribute the net estate. So the net estate is the estate of Murimi wa Muthoni minus the debt that is owed to the divorced wife. And then whatever remains to pay beneficiaries. But normally by the time the divorce 1 week, hey, hawa watu wezi wachelewesha eti 1 week after divorce ushawapea mali yao wameenda haraka sana. So yeah, so anything that is owed to a divorced wife is not part of the estate. So it's not part of the estate. So you have to first remove it, and then whatever remains is what you are sharing. Tuko sawa?
Tuko sawa.
All right, Stanley, you have a final question.
No, Mwalimu, it's only that I didn't lower my hand.
All right, sawa. So that is a question to do with dependents. That is dependent, that is children, that is wives, and everything else. Now, the next thing that also I need to make clear is the next topic. Before we start the first part of probate, the next thing is the relationship between the law of succession and customary law. It's very, very important for you to understand the law of succession and customary law. Okay, so let me try and scroll up to section 4.2 actually. So you also need to understand at what point is the customary law coming in, and at what point is the law of succession coming in. Are you together? Okay. There's an employee of mine that I hired to be telling me whether we are together. You are fired twice. I will now sue you. Okay, so you can see the screen. You can see the screen. I don't know where he went to. Maybe he has slept. Unajua vile kazi kupata ni ngumu. Nakupea kazi na unalala kwa kazi. The estate of a person dying before the commencement of this act are subject to the written laws and customs applying to the date of death, but nevertheless the administration of their estate shall be commenced or proceed so fast as possible with this act. So what is the meaning of what I've just read? So remember, this act commenced in 1981. So if the person died before 1981, we don't apply, okay? We don't apply the law of succession in distributing the estate, but we apply the law of succession in the administration. I don't know whether you guys are understanding that. So the first one is the estate of a person that died before 1981. So if you die before 1981, the distribution of your estate will be subject to your customs. So whatever your customs are saying, if your customs are saying that women will not inherit motor vehicles, we can't give a motor vehicle to the lady. Okay? We can't give the motor vehicle to the lady because that is what the custom is saying. However, we will still use the law of succession for purposes of administration. So what is administration? We will apply for a grant as per the act. We will apply for the grant. We will do all processes and procedures according to the act. But when it comes now to the actual distribution of the estate, we shall ask ourselves, as we are drawing the schedule of distribution, we shall ask ourselves, okay, what is the custom saying when it comes to land? Land shall only go to the sons. We can only give land to the sons, okay? what is the law saying in terms of money in the bank? So that exactly what we're saying. So if the person died before 1981 without a will, of course, okay, without a will, then the estate shall only be distributed according to their customs, but the administration must be done according to the act. Administration simply means that you are applying for grant. You will apply for the grant using the act. I mean, still, but when it comes to the actual handling of the physical properties and the distribution, you ask the customs what they are saying. Now you need to be very careful. Rono versus Rono. You need to be very careful, very, very careful in this extent. You will be told that somebody has come to you and they're saying that they have been exempted. They've been exempted. They are the female beneficiaries. They've been exempted from inheriting the estate of the deceased person because they're just ladies. How can you help them? Don't be emotional, please. Don't be emotional about it. Don't start saying, oh my goodness, that is very wrong. Article 27. Calm down. Okay? Calm down. First, interrogate the law. Okay? You will come to section 2 and ask yourself, when did your father die? My father died in 1980. So once you know that the father died before the commencement of the act, then you cannot outride the customs. So the customs will apply. And if the customs are saying that women will not inherit, that is what it is. Sad, but what it is. Okay? So ask yourself when the person died. And then if they died after 1981, that is when you can start qualifying it by making reference to the Constitution, non-discrimination, and the beneficiaries under Section 29, where we are saying that all beneficiaries will inherit regardless of gender. Okay, so I hope that makes sense. I hope that is clear. That is the first instance or the first point of interaction between the law of succession and the customs of the deceased person. The second one is under Section 33, actually 32. In terms of intestacy, let me just move there quickly so that we can wrap it up. And I hope you guys are formulating questions that you need to ask. So write down your questions so that we can have a question session, and then we can. Oh yeah, so 33. 33 says the law applicable to excluded properties. Now remember that under Section 32, there are certain properties that are excluded from the rules of intestacy. Now the rules of intestacy are the rules that determine how your property is distributed if you don't make a will. Okay? They are called the rules of intestacy. Now, if you don't have a will, then the rules of intestacy will come in and your property will be distributed according to the rules of intestacy. Tuko sawa? And that therefore means, and I want you to understand that therefore means that when you come to 32, it gives an exception to the rule by saying there are certain properties that are exempted from the rules of intestacy. It means therefore that even if you don't make a will, the rules of intestacy will not apply. Which properties are those? Agricultural land, crops, and livestock in the following districts: West Pokot, Wajir. I don't know why our friends from Wajir pronounce that one as Wajir. Let me pick someone here. Is it Wajir? I saw someone else, someone called Pfizer. Is it Wajir? Oh.
And
Or
we pronounce it both ways, either Wajir or Wajir. It's both applicable.
where's I don't see Anyway, so they say Wajir or Wajir. It's Wajir. Yes. So Turkana, Garissa, Marsabit, Tana River, Samburu, Lamu, Isiolo, Kajiado, Mandera, and Narok. So if you have agricultural land, okay, crops and livestock in these specific districts, and you don't make a will, then the law of intestacy will not apply. But under Section 33, they say the law applicable to the distribution on intestacy of the categories of property specified under Section 32 shall be the law or customs applicable to the deceased person's community or tribe, as the case may be. So if you have properties in these places and there are agricultural land and there are livestock or crops, then we shall use the law of your custom when you die. Okay? And that therefore means whatever your custom say, that is what we will do. That doesn't mean you can't will away. Somebody might have told you, you can't will away your livestock or your crops. You can. You can do that. But you have to have them in the will. If you don't have them in the will, and they are in these districts, we shall use the customs. Are you together? So this is only an exclusion. Remember, they are excluded from intestacy, not testacy. So you can still be in Wajir and have a will and insert your agricultural land or crops or livestock in that will. But if you don't make a will, then the customs will come in place. So those are the two interactions point between the law of succession and the customary law. Are you together? One person raised their hand. Who is that? Yes, Dorothy?
Could you kindly repeat what you just said on the point of when you put this in the will, any property under Section 32? What law applies?
The law that applies is the will. That is, the will is what applies. So remember, we have testacy and intestacy. So this one is testacy alone. Okay? This one is testacy alone. It means it will only come to place. The rules under Section 35 all the way to 40, which falls under Part 5, are rules of intestacy. These rules only come in when there is no will. We don't have rules of the will. The will just apply as it is. Okay? But if you don't have a will, the rules of intestacy will come in, where we will tell you how to distribute your property. But if you don't have a will, and you have property like these ones that are here under 32, agricultural land, crops, and livestock in the following districts, then we will not use the law of intestacy, but we will use your customs. Okay? At the same time, it doesn't mean you can't make a will. You can make a will. So if you are in Marsabit and you have some agricultural land, make a will. If you don't like your customs, make a will and let the will be the deciding a factor. So make a will and have your crops and your livestock in the will, and that is, you'll be safe. But if you don't make a will and these are the properties there, and that is the district they're coming from, then you will have to contend with the rules of your custom. Tuko sawa?
Yes, thank you.
All right, questions now. I want to take questions. The only thing now remaining for us now is things to do with the part 1 of probate, which is testacy. The question to do with the wills. Now, probate is very easy, guys. I keep saying that, but maybe you think I'm biased, but probate is very easy. It's a very simple thing, just normal things. Don't overthink it too much. Okay, it's a very simple thing. Just know what needs to be done at all the time. Okay, so that is that. So the next thing we need to discuss is now the question of testacy. The question of testacy and on wills and everything else. So that makes our first lesson on introduction, the question of beneficiaries, the question of everything, and up to there. But if you've read ahead and you have a question that you read ahead, we could discuss it right now. But from my desk, I know it's Friday. Some of you want to go and sherekea, yeah? You want to go and partake and drink something. Wachana pombe. One day you'll drink until when you wake up, it will be January 2025 when the exams had been done and had been marked. That's when you'll wake up from your enjoyment. You'll miss the exams. So don't partake. Kunywa tu chai na ulale. Hautakufa kesho. Najua kuna wengine wenyu wanatumia headphones wako kwa sherehe mbaya. Washafika. Anyway, I want to let you go and you need to have a good evening, but we can discuss a few questions if you have. Joy wa Ruiru. Are you from Ruiru? Joy?
No, from Ruiru.
Okay, proceed.
Okay. I had a question about section 32. The included properties. I saw a question whereby they just named the name of a place called North Hor, and they didn't tell us whether it's in Marsabit or Garissa or any of those listed properties. So in an exam situation, what do you do?
Normally they specify. So
yes,
even in that North Hor, sometimes the examiner is not interested in the exclusion. Sometimes what is being tested is not the exclusion, but normally they will specify the section. All the questions I've seen, it is specified. But if it is not specified, the name will be easy. But at least nyinyi pia tembeeni Kenya, mjue Kenya. North Hor, kuna wengine hata wajui North Hor iko wapi, wanashangaa tu hiyo bado iko Kenya. Yes, it is in Kenya. But the examiner will make sure that it is clear. In Narok County, at least they'll tell you counties so that you know which county is this. But there are some other names that if you hear, you just know where they're coming from. Okay? If for instance, if they said this person is in Kajiado, just know that's Kajiado. If it's in Kitengela, that is Kajiado. So it's the examiner will make it easy. Yeah.
Okay, thank you.
All right. Someone else called Tianga Jennifer.
Yeah, when you were discussing the relationship between law of succession and customary law, you mentioned the Rono versus Rono case. I didn't get how it was the relationship in that case.
The Rono versus Rono is whereby they excluded the female beneficiaries, and of course in that instance it was the opposite. They said that because the law of succession does not mention the gender of the beneficiaries, and the Article 27 specifies that nobody should be discriminated, and also Section 38 of the law of succession says that beneficiaries the children of the deceased person will benefit regardless of gender, male or female. Then the act in Rono versus Rono was unconstitutional, and therefore even the female children would inherit. So that therefore means before you quote Rono versus Rono, then you have to be very sure that the law of succession is applicable or the customs are applicable. So when it comes to the question of females inheriting and customs and everything else, you have to look at Rono versus Rono. But in terms of asserting, an argument that all children should inherit, then again, Rono versus Rono. Tuko sawa?
Yes, sir.
Okay. Joy, you still have a question? Your hand is still up.
Sorry, I forgot to lower my hand.
All right, it's okay. So fine, if there's no question, guys, that is it for today. Have a great night. This is the last free class. We'll not have any class tomorrow and on Sunday, but we will resume the normal classes now on Monday for 7 days a week until the last exam is done. The only day we will not have exam, the only day we will not have a class is until the last exam is done. So take your time over the weekend to organize yourself, and we resume on Monday to pick it up on a serious scale and see how much work we can cover within the time. So I've stopped the recording and I will share the recording in the chat, but you